All right, so here are a few things that if after the eviction itself, if a judge rules against you and they evict you, you have a couple of options. You have 5 days to ask for a new hearing, and that's usually relating to some specified reason. You know, you could ask for a new hearing because, you know, maybe you discovered some other piece of evidence or something that you didn't have on the day of the hearing, or there might be something else that comes to light right after that. You could also, within that kind of same time frame, ask almost, you know, in a way similar to reconsideration, what they call it, kind of saying, well, Judge, I think you should reconsider because I think you got something wrong or got something with the law wrong. While technically you have 30 days to appeal a judge's decision in an eviction, not really. And the reason I say not really is what's right below that. You could have to leave the home within 48 hours. The way a writ of ejectment works, and the problem with a writ of ejectment is it's not really a clear time frame practically. Landlords will ask for the writ of ejectment. They'll pay their $10 to the court. The court then has to proceed with executing that writ of ejectment and putting that writ of ejectment, serving that on you, and then enforcing it. Once they serve a writ of ejectment and they're going to enforce it, they have to come back at least 24 hours later. In my experience, a lot of magistrates, the constable who does that and then comes back, or they come back with the sheriff's deputy or someone, they usually have some kind of a process that they do. Different courts will have a slightly different process. And it's good to follow up with them to know what their process is so you are better aware of what your actual time frame is. If you want to appeal the judge's decision and stay living where, you know, in your residence while that appeal is going forward, then you better do that appeal before they actually put you out with that writ of ejectment. It doesn't matter if they've served you with it when you do your appeal. You just, in order to stay there, you're going to have to still be there. So it says 30 days, but if the constable is bringing a sheriff's deputy to put you out, you know, on the 15th of the month, and technically you should still have to the third. You should have another 10 or 15 days to do your appeal. Well, if they put you out, it's good. It's not going to seem like there's a lot of point to your appeal at that point. So while you do have 30 days, keep in mind, if you want to stay and you want to appeal, you better appeal it to the Court of Common Pleas prior to them actually putting you out of the home. And that is something that we always have to be aware of. I've had many cases where something happens and that 30 days really shrinks to just a few days or 5 days or something like that before the person's going to get put out if I want to stop it.